And we are live. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth. Draw near, give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
All right, this is single justice matter. It's a request for a stay of execution of sentence in the case of Jeremy RYDER. The case is 2020 P. Oh, I'm sorry, that's not it. Or do we, which number do we use? Do we use the same number as the appeal? Or maybe we do. 2020 P 1049. And will counsel please identify themselves?
Good morning, Your Honor. Karen Pickett for the appellant, Mr. RYDER.
Good morning, Your Honor. Assistant District Attorney Donna Marie Herron for the Commonwealth.
So good morning, folks. I'm Judge Englander. I have read all the materials, maybe not quite as carefully as I would have if I had had my extra half an hour, but I've read them. I have a number of questions. But why don't we start with counsel for the defendant?
Thank you, Your Honor. Your Honor, I just wanted to confirm that you did receive, I filed the motion for leave to, okay, thank you.
And I read it, and your motion is granted.
Great, thank you very much.
That motion. Motion for
right,
leave
well,
to file.
let's just turn the
motion for leave to file the supplemental material is granted.
Boo, boo. As Your Honor knows, from reading the materials, Mr. RYDER was convicted of 2 counts of indecent assault on a child under 14. He filed a notice of appeal. I've briefed the appeal. The Commonwealth has sought an extension and hasn't responded yet. But in the meantime, while the notice of appeal was pending, we did file a motion for stay before the trial judge. We had a hearing. I filed a supplement to that. The judge had another hearing, and then ultimately denied the motion for stay. As Your Honor knows, the judge's denial was based on a number of factors. One thing I wanted to point out, and this isn't the judge's fault, is that I hadn't really fully briefed the appellate issues, and in fact, I have more issues on the appeal than I presented to him, and so I just want to make that clear. The second point is that after he issued his decision, the SORB decision came out, and if Your Honor had a chance to sort of look at least at the conclusions of that, the SORB.
When was that issued? I saw it was. I saw that the hearing was August of 2020, but I couldn't see a date on it for when it was issued.
Yeah, the clerk emailed me the decision from Judge Lecanto on October 8th. And I received, I believe
no, I'm not talking about Judge Lecanto.
Oh, the SORB report.
I'm talking about the SORB decision.
I believe it was October 16th. It was emailed to me on October 20th from counsel, SORB counsel for Mr. RYDER. So as Your Honor knows from Nash, I'm asking Your Honor to review this motion to stay de novo. Obviously, I'm happy to talk about the legal claims that I have if you have questions about those. And I'd like to talk obviously about the security issue. And as Your Honor knows, Judge Lecanto basically, again, because the direction from Nash hadn't come out, but basically he said, oh, you're just as safe in prison as you are, outside, which I think contradicts Nash and Christie and all that stuff.
I understand Nash, and I've got that part. And okay. Is it, let me just ask,
sure.
You say that your client suffers from prediabetes and hypertension. Is that right?
Yes, and asthma.
And asthma. Is that contested by the Commonwealth in any way?
No, it's not, Your Honor.
Okay. And just get me the dates again. He went into prison on what date?
I know at the time of sentencing, he had 225 days in, I believe.
If I can help, Your Honor, on August 31st, 2018, the defendant was held without bail and remained so until he was sentenced on August 8th, 2019.
So he's been in jail over 2 years at this point.
Yes, Your Honor.
Yes,
Of
Your
his
Honor.
3.5-year sentence, right?
Yes.
Okay. So I think that the two issues I want to hear about are not the COVID issues, but the issue of the substantiality of your claims on appeal.
Okay.
Understanding Nash as well as I can, having read it this week.
Yes.
And also the issue of his risks of flight or to society if he's released.
Yes, Your Honor. So as Your Honor knows, I've raised essentially 4 issues on appeal. And within each issue, there's a couple sub-issues. I've raised the issue of the impanelment of a juror that I believe should have been struck for cause, the issue of the prosecutor sort of rehabilitating the witness proactively, which I argue is in violation of the first complaint doctrine.
There was no objection to that when it was done, right?
Yes, you're right, Your Honor. That would be under a substantial risk analysis. The third issue is sort of 2 evidentiary issues, one of which was objected to and one of which was not. But the issues were that that the prosecutor was allowed to gather from the victim's mother that Mr. RYDER essentially blacked out when he was drunk. And the other issue was that the victim had testified that during the alleged assault, she had pulled a knife on Mr. RYDER, and then subsequently kept that knife underneath her pillow, apparently, or her bed. And at one point, Mr. RYDER's counsel asked the mom about finding a knife, and she said that that happened in the summer before the alleged incident. And she also started to testify that she found a picture of her dad, the victim's the victim's grandfather, that the victim had somehow like X'd out his eyes with a knife. And I would argue, Your Honor, this whole case, boils down essentially to the victim's testimony. There was no confession, there was no physical evidence. The first complaint was made almost, 8 or 9 months after the alleged incident. There was no specific date assigned to the incident, which I understand is allowable, but it obviously puts...
But September of 2017, when she's 10 years old, is that right?
Yes, and I believe at trial she was 12, I think she was 12 years old when she testified at trial. And the Commonwealth, it was funny because the victim's mom was called by the defense because she could testify that the victim sort of hated Mr. RYDER. And it sounds like things were, terrible in the house, and I don't blame her for that. But at some point, the Commonwealth then turned it around to say, because she testified, I wasn't surprised that this allegation was made because of how she feels about the defendant. And as you know, in closing argument, the prosecutor then said, the victim's mom testified that she wasn't surprised that Mr. RYDER had assaulted the victim. And that's a huge, huge problem in a case which I would argue, Your Honor, is
what was the exact language of the prosecutor?
I'm sorry, Your Honor, let me just look it up in my brief. I have it here. So it says, the prosecutor argued that Miss Andre, who's the victim's mother, stated when she was told about the nature of this offense that she, quote, wasn't surprised that something like this was going to come eventually, and she agreed to that. When I asked her if that's the statement she made, she said, yes. She wasn't surprised to find out that her boyfriend had sexually assaulted her daughter. And Your Honor, I would submit that that
Was
is
there an objection to that?
There was, and there was an objection, and essentially the judge said, well, that's for the jury to decide. But it certainly was not in line with Ms. Andre's testimony.
What did the judge do with the objection? Did he instruct the jury specifically?
He did not instruct the jury, and if I remember, and maybe the prosecutor can correct me if I'm wrong, if I remember, I think he basically said, this is for the jury to decide. I don't think my client's counsel asked for a curative instruction. If I may be wrong with that, Your Honor, I apologize. The other issue.
Okay, what about, I understand those arguments for the most part. I may come back to some of them. What about the Judge Lecanto's finding, if you will? Court finds that the defendant represents a significant danger to the public if released. Bases that conclusion, the defendant's criminal record, which includes a history of substance of alcohol abuse, history of defaults and noncompliance with probation, history of violence. What do you say to that?
Well, Your Honor, I would say that I know the judge said that, but I want to point, Your Honor, to two things. One is that the Sorb decision discusses his history, and he does have a long history of involvement with the courts. I believe the only violent offense was the one that there was a complaint from the victim's mother after this alleged incident happened. Excuse me?
One in 2017 and one in 2018.
Okay.
By my reading of the Sorb opinion, you correct me if I'm wrong.
Okay, so and I think
weren't there violent crimes going back, many years earlier too?
I don't think so, Your Honor, because I've looked through his record here. It's a lot of possession with intent to distribute. There were other charges a lot of the charges were dismissed. But in any event, I don't dispute
that. If they're dismissed, then they don't count?
Well, some of them were dismissed not because of the completion of probation. Some of them were dismissed just outright. So it's a long record. I don't want to argue with you that this is a choir boy here.
Isn't that important? What do I do with the judge's finding? He calls it a finding.
Well, first of all, Your Honor, as Nash says, you're entitled to evaluate the security risk yourself de novo. I understand, and I also think that you have information, very detailed information that wasn't before the trial judge based on the Sorb decision. In that Sorb decision, the officer finds by clear and convincing evidence that my client does not present a significant risk to the public. He has family support. He can live with his wife. There's no children in the home. The alleged victim doesn't live anywhere near Clinton anymore. He can work with a friend. And perhaps most importantly, Your Honor, Mr. RYDER has a very, very significant history of alcoholism. And I believe looking at I've done this a long time, looking at this record, I can see that these are a lot of things that were done when he was intoxicated. And he's been sober now for 3 years. Even before this case was brought, he had entered into rehab. And so as the Sorb officer found, after hearing and in great detail, he has the support to maintain sobriety. And she doesn't believe that he'll be a significant risk to the public. And that's why he was classified as level 1.
What do you say, counsel? What's the Commonwealth say?
The Commonwealth asked you to deny the defendant's motion for a stay. We're not actually challenging that the defendant meets the first prong of a successful, just the way Nash has written. Frankly, I think if you file anything that's not frivolous, then you meet the first prong. And I believe the defendant has not filed the frivolous brief. So the Commonwealth
I thought Nash said the contrary. I thought Nash specifically said, we're not saying anything that's not frivolous is enough.
Yes, but there's also, I would suggest overturning Judge Wolahogian's decision, and then I think hers was Nash case, in which she didn't find that the If you want to say I'm wrong, I'm more than happy to, Your Honor. It's just my reading
Well,
of the case.
I will suggest to the Commonwealth do not concede that in each case. What I do think in this instance is that the prosecutor's comments are troubling to me, and I was going to ask you if there was any kind of specific remedial statement made in response to the, she wasn't surprised that this, that Mr. Ryder assaulted her daughter.
I don't believe so, Your Honor. I think the judge did say it was up for the jury to decide.
And
And
there's
then
another,
I think
the next comment underneath that, which says basically something like, when you're that drunk, you do things, again, arguably beyond the evidence in the case. To the point where I'm not saying that you win, Attorney Pickett, but I take the Commonwealth's concession as to the first element in this case. And I note that each of those things are at least of a type that probably meet the new Nash standard. Let's put it that way.
so.
So we've got a colorable argument on appeal. We have somebody who has not only is incarcerated, but has indicators which give him a heightened concern with respect to COVID. He's already served 2 years. If we let this drag on much longer, even if he wins on appeal, he's going to have served his whole sentence.
Yes,
So
but the
why is it that I should deny this motion?
because the defendant has a 13-page record, which includes, it does include convictions of assault with a dangerous weapon, assault and battery, burglary.
Where are those?
Malicious.
Because I didn't see those referenced in the Sword opinion.
That's in his record.
Yeah.
it is
When was he convicted of what?
2001 assault and battery on a police officer.
2001. So 20 years ago, when he was roughly in his early 20s. He has an
Yes, Your Honor.
is that the one? 7/10/2001.
Yes, Your Honor.
Battery.
Then
Was
leaving
he?
the scene
What was his sentence? 6 months?
yes, Your Honor.
6 months suspended.
Sorry, I'm looking at it now. Can you give me 1 second? I apologize. Well, he ended up serving the 6 months, Your Honor, because he violated. And that's my other point. Every time this defendant has been put on probation, he has violated probation. So he's being asked to be released on
When's the
term.
last time that is that the only violent crime other than the 2 instances with the victim's mother? Is that the only violent event on his history? Do we have any others?
I think it's a malicious destruction of property, but that wouldn't be against a person, obviously.
Assault with a dangerous weapon, convicted in 2000. Is that right?
Yes, Your Honor.
Or is that dismissed? That's dismissed. Sorry. That's dismissed. I was looking at the C, which I know
apologize.
is irrelevant. I'm just learning how to read these. Apologize. Anything else? Any other violent crimes other than the 2001 and the 2 events in 2017, 2018?
No, Your Honor. There's other crimes against property, leaving the scene of property damage, and drinking under the influence, and drug possession.
When's the last time that he violated probation?
Give me 1 second, Your Honor. Violated it in 2006. And hold on, he also 2010 for leaving the scene of property damage. He violated it. 2017 for possession of Class B. Sorry, I'm just reading it now. I apologize, Your Honor. 2017, operating under the influence. He violated probation. He also violated it for possession of a Class B substance. and was given jail after each violation. So the Commonwealth suggests this defendant is not the type that obeys by court orders and therefore has grave concern that any condition while released he will violate. The Commonwealth also would like to state that the defendant claims he's been sober, as in the sober report, for 3 years, but he's been incarcerated, as you've noted, for over two years of that time. And the
That does mean that he's been sober, and he apparently will have, presumably, under those circumstances, gets whatever treatment is needed in order to tolerate the sobriety.
The Commonwealth would also like to note that the SOAR means low risk to sexually reoffend. I don't believe it means low risk to never commit another crime. Would like to note that.
How do I analyze that, though? I mean, the crime that he stands convicted of and that we're worried about is a sexual offense, right? So is it a consideration in staying the execution of that offense that he's been violent otherwise? Or isn't the consideration in staying the execution that he's at risk of doing the same thing that he's been convicted of again?
My reading of both Nash and Christie and Hodges and the like is a risk to the safety of the community, is the way I read those cases. So I think you do consider his violent past. I know the court does also, Nash makes it clear that this is not a burden on the defendant, but the Commonwealth just likes to note for the record that Worcester House of Correction, since this pandemic began, has only had 4 inmates test positive.
Nash says you can't look at that. Literally just flat out says that that's not relevant, right? You're not allowed to look at the conditions inside because they can change so rapidly that that is not a proper consideration. I mean, if I'm wrong, show me where I'm wrong, but that's literally what I thought the opinion said.
They do say can change at any moment. They say you look at the general risk and the specific risk. But
right.
They said keeping an eye,
right?
Keeping an eye to the.
He has a general risk because he's in a prison population. He has a specific risk because he has pre-diabetes, hypertension, and asthma.
He does, Your Honor, but Christie, which is not overturned, also says the court should do careful considerations of the circumstances under which he will quarantine if he is released. And quite frankly, we don't have any affidavits, not that the burden's on the defendant, I get that, but just to consider it, there's nothing from the defendant or his wife or any of that, although he says he will live with his wife.
Where does he say that? Let me go back to your sister on that. That's a good point. So a couple of things.
Yes.
First of all, what's in the record as to what's going to happen if he is released? I take it that he would go back to his ex-wife, who is not the victim's mother. Is that right?
So, yes, she's still currently his wife, Your Honor. They were legally separated, but they're back together.
Well, how do we know they're back together? What evidence do I have of that?
Well, I mean, I wouldn't misrepresent anything to the court. I talk to her probably every week, and she has been very concerned for him. She talks to him every day, and she has said that she wants him to come home with her, and that there's no children in the home.
Is any of this in the record that was presented to the judge?
It is in my, I do say in the motion that I filed below, that he was going to stay with his wife. Her address is in the SORB report. It's in Clinton, Massachusetts. I do have an affidavit from his former employer.
He testified at the SORB hearing, is that right?
Yes, both my client apparently and the wife testified at the SORB hearing. And I also presented.
Hang on for 1 second. Counsel, what should I do with that? I mean, I have these findings from SORB that suggest that he's going to be back with his wife, live with her. Is that relevant?
It is relevant, but that's all we know. I don't know who else lives in the place where they're living at. I also, what he's planned to do for a job, from what I can understand from the record, is to be a handyman / contractor, which again would put him at risk for COVID, because then he will be out in the public in different areas.
That's an argument that he's more at risk out of the prison than in the prison. I think Nash forecloses an argument like that. I mean, that's the way I read Nash. I think it forecloses that argument. And that's one of the things that was argued to the judge and that he accepted, and that Nash, literally, that's a leg of the stool that Nash has cut. At least the way I read it.
I understand.
What about the fact that your client has chronically shown that he can't abide by the rules of law.
Yes, Your Honor. I've seen the
he's
record.
violent, right? I mean, he's been violent multiple times. He's violated probation multiple times. Where does that lead me? And what do you say to that?
Well, again, I'm not going to pretend he's a choir boy, but I know I'm relying heavily on the SORB report, but it's very detailed. And basically what the officer, I don't think they're called judges, found is that a lot of this is based on his drinking. He was a bad drinker. And ironically, I don't disagree with the prosecutor, what she said, not that she was allowed to say it, but it's true. I mean, alcoholism makes people do things that they shouldn't do and normally don't do. But as the hearing officer found, he has been sober for 3 years. He's committed to his sobriety. He has the support of his wife and his dad and his friend who wants to employ him.
Okay,
And
all right. I'm sorry. I understand this, and I think I'm getting close to everything I need to know. Here's a concern that I have. You rely very heavily on something that was not before the judge.
yes,
So, oh, I see. But you're saying to me, if you do this on a de novo basis, then you can pass that problem.
yes. And
Sorry,
Your Honor,
I missed the significance of that.
yes, and Your Honor, Judge Lecanto is incredibly fair to me. I think he's, a good judge. I enjoyed arguing in front of him, but they're busy. They're very busy, and it took a really, really long time to get a decision. And I don't think Mr. Ryder has time to wait. I don't know if Your Honor saw the WBUR report, and it's not in the record, but I saw that 2 inmates in state jails died last week. It's a crisis. It's an emergency, and that's why I'm requesting that you review it yourself.
Okay, thank you both for your
Thank you.
argument. Commonwealth, is there anything else that you'd like to tell me? Because I've heard, I think, everything that Mr. Ryder's counsel wants to tell me.
Nope, the Commonwealth will rest.
I appreciate the candor and professionalism with which this was presented, and I thank you very much, both of you. I'll get this decision out as quickly as I can. I can tell you that won't be today.
Okay.
Thank you, Your Honor.
It turns out that there are a number of things before me, but I'm going to work as diligently